So as Mark mentioned, healthcare fraud and abuse is a very broad topic, and we could spend months talking about this. So we're going to give you kind of the 10,000-foot overview of some of the healthcare fraud and abuse laws that we work with and deal with every day in practice. Do we have the? Oh, here you go. Okay. So we'll discuss the Stark Law, the Anti-Kickback Statute, which you often hear referenced as the AKS, and Beneficiary Inducement Statute, the False Claim Act and Overpayment Statute, Enforcement Agencies and Mechanisms, the Exclusion Statute, the Eliminating Kickbacks and Recovery Act of 2018, or ECRA, which is a newer regulation, and then we'll go over some practice tips. So healthcare sales and business dealing settings is unique. Anyone who practices in healthcare will know that standards that some other businesses are able to do or arrangements that they can participate in are not legal in the healthcare space, which is interesting whenever you're dealing with the business clients because they don't understand why some of these arrangements don't work or can't be done, and you have to be prepared to push back sometimes and be able to really explain to them the details of the issues with the arrangements and the laws. Every healthcare business engages in activities that are regulated by these fraud and abuse laws, and non-compliance is a source of risk for clients, their providers, customers, and partners. So there has been an increase in enforcement over the years by the government on these issues, so it's really important to understand them and focus on them in diligence on transactions, or be able to answer client, do what?
No, it's like correct.
Oh, or client questions. The potential for non-compliance under Stark is a strict liability law, so it's, in my opinion, kind of what we focus on first whenever we're working with clients, because it doesn't matter whether they intended to be non-compliant with the law or not. They are liable regardless of their intent.
Yeah, even if it was a mistake,
yeah.
Which we get a lot where the health system or the provider is like, we just made a slight error. We forgot to provide notice of advanced imaging services. And you're like, I know it's horrible. Unfortunately, you violated Stark Law.
Yeah. I had a transaction recently where someone said on the call, they said, but it was just like a de minimis amount. It's really, really a gray area. I'm like, no, with Stark, like there's really
It's
not a gray area. It's just wrong. It's non-compliant. So you can't, as we all know, you can't expect perfection from clients and from the healthcare system and providers, but unfortunately, the regulations, especially Stark, demand it. So there are ways that you can kind of not fix, but you can report Stark through a self-disclosure. And we can talk a little bit more about that later. Clients don't like to do it, but it's kind of really the only option once that you know that there's a Stark violation to file a self-disclosure and move forward to kind of avoid liability.
Or making an immediate overpayment if you catch it early. Yeah. Let's see. So definitely identifying and being able to issue spot some of this fraud and abuse issues in whatever area you're practicing, either advising clients on a day-to-day basis or doing transactions, which I'm sure many of us do. You're called in as an advisor on deals, especially in the healthcare space. So it's very essential that you do build that skill set to be able to identify these issues, even in structuring different arrangements across different practices. So as we mentioned, we'll be talking about the Stark Law, the Anti-Kickback Statute, or the AKS, the Federal False Claims Act, the Civil Monetary Penalties provisions, and ECRA. And so these laws are generally aimed at curbing or punishing those who give or receive a benefit in exchange for referrals to a federal health care program, or source are sometimes giving money to physicians in exchange for referrals. And some of this law also goes past physicians, right? Like the anti-kickback statute we'll talk more about sort of covers everyone. And then you get into a law like ECRA that sort of covers not just government payers, but also private payers. So these laws sort of like have their tentacles everywhere. So one might just be to physicians, like the Stark Law, and then the kickback comes in, it's like, I don't care if you're a physician or not. And then ECRA comes in, it's like, I don't care who your payer is. That's sort of how I think about these laws. And so we'll also have laws that also include fee splitting, brokering prohibitions, and even though we're talking about on the federal level, just keep in mind as well that there are similar state laws that are often patterned after these federal laws as well. So while we are discussing issues on the federal law, as you are doing your different analysis and looking at arrangements, you also want to look at whether there are similar laws at the state levels that would impact your analysis.
And as they mentioned in the previous presentation, and Mark mentioned during his introduction, if the provider doesn't participate in government, federal healthcare programs or government programs, they're not subject to at least the Stark Law. And so you really don't have to go through that analysis unless there is kind of a state referral prohibition that you have to look at, which is helpful. And to Mark's point, that the government cares a lot because they're paying a lot of money for these healthcare programs. All right, so I'm going to go ahead and start talking about Stark. So a judge in the United States Court of Appeals for the Fourth Circuit, they have this quote here, which I think is very fitting, said, "It seems as if even for well-intentioned healthcare providers, the Stark Law has become a booby trap rigged with strict liability and potentially ruinous exposure." It can really impact providers. So I work primarily on the private equity physician group practice side of healthcare transactions. And a lot of these physicians, they all want money, right? So they all are trying to structure their arrangements where they are going to benefit financially the most. And they think they understand, and they don't realize that there are such strict regulations around how they can be compensated. And sometimes they even, will say, we've had an attorney look at this, we have great counsel, and oftentimes that's true. They have had an attorney draft the agreement, they do have great counsel, but it goes beyond that, and there are many places where you can misstep and run into problems that we'll kind of discuss as we go through the Stark Law in the actual implementation of arrangements and other areas that can become problematic. So the Stark Law generally, which most of you probably know, but we're going to kind of start from the beginning and go high level here, requires a physician. So if there is not a physician involved in an arrangement, then you are not in Stark Law. You are not in a Stark world. So sometimes people will say, like I recently worked on like a digital health arrangement that was with a lab and a hospital directly, and with sparing you all the details that are kind of irrelevant to this, someone said, well, what about Stark? And I'm like, well, where's the doctor? Like there wasn't a physician involved. And they're like, oh yeah, we're in kickback. And I'm like, right, it's a kickback problem, not a Stark problem. So no doctor, no Stark. So a physician cannot make a referral for designated health services to an entity with which the physician or an immediate family member of the physician has a direct or an indirect financial relationship. And the entity that furnishes that designated health service cannot bill or submit a claim to Medicare for such services unless the relationship with the physician who's ordering the DHS fits into an exception. And Aditara will talk more about kickback later and kind of how this differs, but under Stark, it has to meet every element of the exception. It can't just generally comply or meet some of the exception. Every element of the exception must be met. And as we discussed earlier, it's a strict liability statute, so the intention of the party is not relevant. Even if they meant to comply, didn't mean to do anything wrong, they are still liable for any non-compliance. So kind of going back where we just went through what the Stark Law is, the 3 questions you ask first is, 1, is there a referral from a physician for DHS? If yes, then you need to keep looking and doing an analysis for Stark. If no, then you're not gonna be in the Stark Law world. The second question is, does the physician or an immediate family member have a financial relationship with the entity that's providing the DHS? And then third, does the financial relationship fit within an exception? As we discussed, if 1 and 2 are yes, then the exception must be met. So you're asking, what is a referral to DHS? What is a referral to a DHS entity? If a provider orders or requests DHS services or designated health services, if there is a certification, recertification, or establishment of a plan of care that includes DHS, and an example of this would be like a physician has to certify a physical therapy plan of care for Medicare patients. And if the physician is certifying that plan of care and the physical therapy services or DHS services, then they are referring to a DHS entity. The referral can be written, oral, or electronic. Referrals by others can be imputed to a physician, so persons under the physician's control or direction, and consulting physician referrals are imputed to the physician requesting the consultation. As with most other defined terms, there are exceptions. Stark has many defined terms. We can't go into all of them today, but we will hit the most important. So certain radiology, radiation oncology, and pathology referrals are exempt. And certain services that can be considered personally performed under Stark and are 100% performed by the physician's own 2 hands can also be exempt. I would note, whenever a physician says that they personally perform services, they will often want to carve out personally performed services from the DHS pool and get what's called direct credit for those codes or those services. But the question can't stop there, because physicians often or providers often will say that something is personally performed when they actually haven't done every element of the service. So a question I often will ask them, and I think they think it's ridiculous on diligence calls, but if you are saying that the x-ray was personally performed, were you actually preparing the patient, getting the patient set up on the table, and were you actually pressing the button? Because if the answer is no, then it was not personally performed for purposes of the physician being allowed to get direct credit for those services in their compensation under the Stark Law. Also, another example that I've seen recently be an issue in physician group practice deals is whenever there are orthotics and prosthetics, they often want to say that the physician wants to get direct credit whenever they order the prosthetic or orthotic, but this would be another session, but there are other requirements for DME prosthetics or orthotic services for an entity that's enrolled as a DME supplier to be able to get direct credit.
And very high level, but just wanted to note that there are certain services that can be credited towards the physician. So we're not delving deep into that, but certain things are considered incident to, right? Where a nurse practitioner or a PA provides the service and the credit can be given to the physician. But the cautionary piece is certain services in the therapy space at least cannot be provided incident to. So sometimes you see those two where they're like, oh, it was provided incident to, it's fine. But then you start to ask what services were those, and are those permitted to be billed incident to? Again, remember, Stark is not just the referral piece, but it's also the billing piece for the DHS entity that's billing for the services.
Right.
Just wanted to know that.
So we talked earlier about whether there was a financial relationship. And financial relationships includes an ownership interest or a compensation arrangement. A compensation arrangement is going to be any arrangement involving remuneration, direct or indirect, between a referring physician or an immediate family member and a DHS entity. So think employment agreements, contracting, consulting, directorship agreements, call agreements, waived fees, Super Bowl tickets, and you might think that's funny, but it happens, and people have, a box at the arena, and they're giving the physician tickets to the playoff games, and, it becomes a problem. We often, see when you ask questions, they're like, well, we do give, this entity like a gift basket at Christmas. Like, not usually such a concern as long as it's not high value.
Yeah.
Or we send a
I've seen
Christmas
spa
card,
dates.
so yeah.
I was saying I've seen stuff where it's like, we give the wives of the physicians spa services and just a whole bunch of different things, and it's like,
I've heard some
that
pretty
might be a
interesting
bit
things.
problematic.
Yeah. And then under remuneration, so with certain exceptions, it's defined as any payment or other benefit directly or indirectly or covertly in cash or in kind. So it doesn't have to be dollars exchanged. It could be services or other things that are being exchanged rather than just money. An indirect ownership and compensation arrangement are also subject to STARK and require a fact-specific analysis. It can include up-the-chain ownership in a management company that manages greater than one entity. And in the physician group practice space, particularly with my experience there, you do see a lot of management service companies because of the corporate practice of medicine where things are structured with friendly PCs, and you have to really kind of track where the dollars are going and where the chain is. And we'll touch on this later, but in the 2020 STARK updates, they did update the definition of an indirect compensation arrangement. And so it has changed in some relationships that may have previously qualified as an indirect compensation arrangement may no longer be. And diagrams will be your best friend if you're trying to decide whether there is an indirect relationship or not. And I don't have a diagram on our slides, but you follow the dollar sign.
Yeah. I usually draw out all the entities. So a simple way I do is an arrow for where the referrals are going, and then an arrow for where the money is going. And so if they're going opposite ways, okay, you have referrals going one way, money going one way, and then you just chart ownership, comp, all the way down.
Yep. So what are designated health services? On this slide, we've got some of the buckets of the different DHS services. So clinical laboratory services, physical therapy, occupational therapy, speech therapy, radiology services, durable medical equipment, outpatient prescription drugs, inpatient and outpatient hospital services, home health, prosthetics, orthotics, prosthetic devices and supplies, and then parental and enteral nutrition's equipment and supplies, radiation therapy services and supplies. So it's noted here that not all, but some DHS are defined by inclusion on a CPT code list that CMS publishes annually. So if you just search DHS CPT codes, a list will come up, and you can pull it up, and it will have a list of all of the CPT codes that it has published in that document that are DHS, and it will tell you what they are. It's not that easy, though. So this is where some providers get in trouble because, one, they don't check it each year because it changes. New codes are added. I don't know that I've seen codes removed, but I've seen codes added.
Yeah, I've seen codes, I'm trying to think.
And then also on this CPT list, like one section, I think it's the 8,000, it's the labs. It says all 8,000 codes are CPT, are DHS, except for these listed. So you could get in trouble if you don't read that caption and you're like, oh, just these codes on this sheet are DHS, where really in that one section it's saying all but these codes. So you've got to really closely check it. And then also not all DHS codes are actually on that list. So an example I could give where people run into trouble a lot is J codes, which are drug codes. And they'll say, well, we've they'll say we've run our numbers and we're less than 5% on DHS for the last 6 years. So, we don't have to do a disclosure even though maybe we made a mistake in our compensation. And you go back and look at their calculation and you're like, well, these J codes that were really high dollars weren't included and those actually are DHS. So you have to look at the categories that are statutorily defined as DHS, as well as the CPT code list. And there's also a DME POS list that is updated quarterly. It's updated several times a year. And that's available, and that helps determine which ones are actually durable medical equipment and which ones are defined as prosthetic, orthotic, and prosthetic devices. It's important, sorry, I should go back. So I would note there too that it can't just be checked once a year, or just, oh, I don't know. Okay, it can't just be checked once whenever they start kind of doing their calculations. It needs to be checked yearly by the provider to make sure that any new codes have been included into the DHS pool. An example I could give is I was working with a gastroenterology client a while back, and initially they had run their codes and they were all correct, and they started doing what's called a capsule endoscopy, and they said, but like doing like EGDs and doing like scopes isn't DHS, and we're like, okay, that's not, but this capsule endoscopy is. And it had recently been added to the DHS CPT code list, and even though in the doctor's mind it was really the same procedure as what they were doing when they were doing endoscopies, one was DHS and one wasn't, and it created what was millions of dollars in a DHS self-disclosure to CMS. So important that they kind of keep up with that and monitor that on an ongoing basis. Okay. Stark law penalties are stark. So claims from prohibited referrals are not payable, and if paid are an overpayment. So the government, if you receive money from the government for DHS services that did not fit into an exception, the government should not have paid, and they are considered an overpayment from the government to the provider. There is a 6-year look-back period, so if you determine that someone is non-compliant with Stark and they are in a position that they have to submit a self-disclosure, which is not a fun process, especially for big practices, you have to go back 6 years. And it is 6 years of pulling data and determining numbers, and it is not only the DHS revenue that was inappropriately paid. So if you, we'll talk about exceptions later, but like, unless you can rely on another exception. So like, let's say a group practice is relying on in-office ancillary services exception, which is what they most often rely on in the group practice setting. And they determine that one code, let's say X-ray codes, were inappropriately included in direct productivity compensation and not included in DHS pool as required in the exception. It is all of the DHS revenue that's tainted, not just the X-ray revenue. So all of their DHS dollars, unless they can fit into another exception. So you could back out some dollars from that disclosure for services that were actually personally performed, or if there is a provider in the group who has an employment agreement that did not include productivity compensation, that would have varied with those DHS pool dollars, then you could back out, back them out of the disclosure, but any other physician would have to be included, and it would be all of the DHS revenue. So civil monetary penalties of approximately 25,800 plus treble damages, and civil penalties of up to 172,000 for circumvention schemes. There could be additional civil monetary penalties and False Claim Act liability for any knowing violations, which we will touch on a little bit later. And then the potential for federal health care program exclusion, which we'll touch on a little bit later as well. So Stark law exceptions. The exception must be met for the physician to refer DHS to an entity in which they have a financial relationship. There are a lot of exceptions, and I'll kind of touch on a few of them, but I will say it's not just as easy as, this is the in-office ancillary services exception, for example. There are many elements underneath that, like they have to qualify as a group practice, and then there are elements that they have to meet to qualify as a group practice. And if any of those elements are blown or not met, then it's a stark noncompliance problem. So some of the exceptions that we frequently see are personal services, in-office ancillary services for group practices, employment, leases, timeshare, and physician recruitment. Some of the general requirements that apply to most of the exceptions include a signed written agreement, compensation that is fair market value and commercially reasonable, set in advance, not determined in a way that takes into account the volume or value of DHS referrals or other business generated between the parties.
All right.
And
So
then we're going to move to kickback.
we're going to switch to kickback. So just briefly, just a high level, the AKS prohibition, I'm going to call it AKS or kickback interchangeably. It's an intent-based statute. So it's not like Stark where if you made a mistake, you're automatically dinged. The government is looking at whether there's an intent. And this is generally referred to as the one-purpose test. So if any one purpose is improper or is intended to defraud, then if you do not meet, then you would violate the AKS. So, but the AKS prohibits knowingly and willfully offering, paying, soliciting, or receiving remuneration, which is anything of value. Again, this is direct or indirect. So it can be from Amber or from Debbie through Amber. There's still like an indirect relationship. So providing anything of value in return for referrals, purchasing, leasing, ordering, or arranging for. So you might be purchasing directly or arranging for the purchase or lease of those services or items in whole or in part and paid for by a federal healthcare program. So you kind of have to have different elements going on. The intent piece, you're offering something of value in exchange for referrals or in exchange for a lease or in exchange for something else that is paid for by the federal government. And so again, as we mentioned earlier, this is not limited to just physicians, it's just anyone who is involved in that arrangement. So the AKS enforcement exists in 3 forms, and I'll go through this quickly. There's the criminal component, so the AKS is a criminal statute. If you are convicted of a felony, you're subject to $100,000 in fines and up to 10 years in prison. So oftentimes you see this DOJ alerts that says certain physicians or certain lab owners or marketing companies have their CEOs or providers, sentenced to prison time. A lot of times it's related to an AKS violation. The civil component, so there's civil prosecution under the False Claims Act. You can pay up to 3 times the damages and $22,363 penalty per claim. So that can add up pretty fast. There are also settlements that are typically in the range of 2 to 3 times the damages. And then there are also corporate integrity agreements with the OIG. So sometimes different companies will enter into a settlement agreement with the OIG. They would have to have someone appointed to monitoring the company for a 5-year period, seeing what they're doing, just making sure that they are in compliance. So it's a sort of having a supervisor sort of over your head on how you implement your arrangements and put together your arrangements. And then there's also the administrative component. So like we said, there are civil monetary penalties. And then I think one of the really big ones, exclusion from participation in the federal healthcare program. So for a lot of providers, like we said, the government is one of the largest sort of payer of healthcare services. And so if you're not getting money or do not have access to get money from the government, that's a huge thing to your revenues.
I would add 2 quick things to that. One, if you're doing diligence on a deal and you ever see that there's a corporate integrity agreement, you should have a lot more questions and dig a lot further.
Yeah.
And the second thing is, even though exclusion for participation in the federal healthcare program would be limited to exactly what it says, the federal healthcare programs. A lot of times the commercial payer agreements will have a representation in them that you are not excluded from participating in government healthcare programs. And so it actually could impact the revenue for the provider beyond the federal healthcare payers if their commercial agreements have that representation, and if the commercial payer were to terminate the agreement once the provider notified them that they had been excluded by the government.
And so, just as the Stark has its exceptions, the AKS also has statutory exceptions and regulatory safe harbors. People generally just call them all safe harbors. And what they do is they protect certain arrangements, even if the intent is to induce referrals. So it's sort of like, we know the intent is to get referrals, but this activity or this arrangement is protected if you meet all these elements. It says it's voluntary. Of course, you want to try to meet those elements. Don't just not meet them. And we'll talk about this a bit more. And the reason why it says voluntary is because you do not get dinged automatically just because you do not meet all the elements of a AKS safe harbor. Rather, the government looks at the facts and circumstances surrounding the arrangement to see if it poses a risk or if there's an intent to defraud. So, and it's narrowly drafted. So again, multiple elements that you do have to meet. So going to an AKS arrangement that's outside the safe harbor, so we call those non-safe harbored arrangements, are analyzed, like I said, based on those facts and circumstances. There are no bright lines. It's looking at intent. So bad intent can negate good intent. Again, going back to that one purpose test, if there's a one purpose or one categorically bad intent, it sort of taints the rest. Corporate intent is collective. Again, you can say, well, I'm a CEO, I have no idea what's going on, or it was just this one party in our organization that sort of did this. It's the entire organization. Going back to bad intent can be contagious. And also intent is not always knowable without hindsight. So sometimes the arrangement is going on and no one is really paying a close attention, but then after the deal takes place or after the referrals take place, starting to piece together the various elements around it. So the purpose of the AKS is to prevent 4 categorical problems. Increased federal healthcare program cost, corruption of medical decision-making, overutilization of care, and unfair competition. So the first prong, like Mark said earlier, the government is paying a lot of money, right, in healthcare services. And so they do want to make sure that costs are not just going up because of someone's fraudulent acts, right? Keeping healthcare costs low. Also, corruption of medical decision-making. This often comes up a lot of times with physician arrangements. There's this whole sort of called white coat marketing, and a lot of marketing companies would have arrangements with physicians that sort of like promotes their products. And so you have to think about it in a sense of, if I'm going to my physician for care, I would like to know that the physician is recommending this service or this product because it's what is best for me, not because, I don't know, company A, B, and C paid my doctor $1 million to push this to their patients. So the government is looking at those different elements, making sure that people are getting the best treatment and the physician's medical opinion is not being dictated by external parties. Again, overutilization of care, that goes along more medical necessity as well. So are you just recommending this product over and over again? Because you're getting a cut of this. So oftentimes physicians might also have medical devices that they might get a percentage of, right? Maybe they're owners in the company. Someone is laughing. There might be owners in the company. I'm guessing you've seen some of those before. And so if I have an ownership interest in this microphone pack, let's say it does great wonders with healthcare services, And so every time I recommend it and it's ordered, I get, 10%. If I'm in a position where I'm seeing patients all the time that might need that service and I continue recommending it, it's easy to say how very soon I can become pretty wealthy. I'm dictating what the patient, whether the patient needs it, I am recommending it, ordering it. And so, and those services are being charged to the federal government. So the government is paying for those services for me to line my pockets. That's not always the case, of course, but sort of thinking of what the government is looking at when reviewing these arrangements. And also unfair competition. So if someone is monopolizing the market because they're a big company, they're able to provide this huge remunerations to individuals, our others are also able to provide those services. And so a core element of a lot of the AKS safe harbors is fair market value, right? So that also sort of helps us understand the intent piece. So if I am paying what is the fair market value, right, unrelated to the referrals, and it's for legitimate and commercially reasonable services, then often likely, right, there isn't a bad intent involved. And for fair market value payments, a lot of times we ask our clients, we as attorneys do not give fair market value opinions. That's not our job. But there are a lot of companies who do that, right? They go out, they see what other individuals are getting paid for comparable services in the location, in the geographic region, and determine what the fair market value is for those services. Also, unrelated to referrals, oftentimes you might see some arrangements, some of the safe harbors that says that the compensation isn't varying based on how many referrals the individual sends to the business or to the company, or how much business is generated for that company. And then commercially reasonable services. You often see this in a lot of the safe harbors as well. An example I try to use is sort of lease arrangements. So I've seen instances where maybe working on a deal where you have a lease between the physician group practice and a company, sometimes a real estate company owned by one of the physicians. And so you're like, why do you need to sort of lease out this much space? You're only providing services a few days a week to only a minimal amount of patient. Why do you need this entire space to provide those services? So that's when you start looking at, is this commercially reasonable? Like, would others pay for this to have this whole space that's not being used and for work purpose? And so those are elements that would often come up as you look at it. So going to enforcement, so like we've said, there's a lot of enforcement action around the AKS. You'll often see the DOJ alerts, OIG alerts, settlements, and so forth. So oftentimes they're around the financial relationships. And so they're looking at, what's the relationship between the physician, who is considered the gatekeeper in delivering healthcare services, and between the other party. So a prominent area of government scrutiny because of physicians as gatekeeper role in delivering healthcare services that produces Medicare costs. Also looking at whether physician expertise is legitimately needed, especially in a hospital setting. So are you just, for hospitals, do you just have this physician arrangement for on-call services when none are really needed, or for other services when none are really needed? Another piece is EHR vendor settlements. We see a lot of this, especially in the marketing arrangements with customers. So with marketing arrangements, OIG has consistently considered 5 factors, right? Because technically you are referring in exchange, you're paying in exchange for referrals when you look at the marketing space and marketing activities. But the 5 factors the OIG generally looks at is the amount and structure of the compensation, the parties engaging in the marketing arrangement, the relationship to the audience, the nature of the marketing, nature of items and services marketed, and targeted audience. So that's a bit more detailed, but those are the factors that the OIG has consistently considered. Another piece is speaker programs. So in 2020, the OIG issued a special fraud alert on this topic. So this is a big area where physicians are paid money to go speak at an event or paid money to fly to an event to go speak. And with this, the OIG sort of said, hey, here are some suspect here are some suspect characteristics of some of the speaker programs. If it's having those characteristics, then maybe this is not the proper arrangement and it would violate the AKS. So sometimes you see a physician being paid a huge sum of money to go make a presentation that has no substantive information or little to no substantive information. Or make a presentation that's not really on any issues developing in the area. So like, this isn't new information. The audience really does not need this information either. Or it's held, sorry, you were gonna say
No,
something.
I was just gonna say you can, in the open payments or Sunshine Act payments, you can also go online and
Yeah.
look up providers, and for several years,
Yes,
it
you
will
will.
show a chart and you can see like which vendor, which company is paying this physician and how much money. And what is it for? Is it for food, or is it for entertainment? Is it for speaking or education? And it kind of gives you a good place to start to ask the providers or to ask the company, what exactly was this for? If there is a provider who has really high dollars that they're receiving from one of these companies.
And we often do that during our due diligence process on transactions. It's sort of a key piece, especially when you see a huge number and you're like, why are you getting paid $400,000 to go speak at this pharmaceutical company? What's the money for? So those are things that the government would look at. Also, is the location conducive to the exchange of educational information? So are you doing a lecture at a football game? How will that really happen? Right? So you start to think, okay, there's something off there. So those are things that you just keep an eye out for as well. Also, so Pharma Code and AdvaMed Code, so they produce, they review OIG guidance, they give guidance every year, sort of looking at addressing the pharmacy space, addressing medical device space and so forth. So they also give out guidance similar to speaker programs. And then the tele-out fraud area, this is huge. So my practice sort of splits with the fraud and abuse, regulatory space, and then telehealth, telemedicine. And there has been a lot of activity in this space, as most of you know, especially with COVID as well. And similarly, there's been a lot of OIG enforcement in this space over the past year and two. And the OIG actually issued a fraud alert in July of this year, cautioning about telemedicine companies who are paying practitioners in exchange for ordering or prescribing items of services when they've hardly even interacted with or met the patients or where there's no medical necessity. So I was working on a case last year where the physician is sort of like, I have no idea, I never provided these services, but then came to find out she did sort of a PRN basis arrangement with a company where she reviewed charts and then would determine if the person needed DME based on those chart reviews. And so sort of explaining to the physician that those were recommendations, like you ordered DME products for physicians you never met, you never had for patients you never met, just based on looking at a chart. So a lot of those type of activities were rampant, in the past few years, and so the OIG has cautioned more and more in this space and has made it known that they are going to be closely watching. Oh, sorry, I didn't. Did I?
No, you're good, but we're running. We're running short on time,
Sorry,
so we're going to
okay,
go,
so we're just gonna go
quickly
fast.
through the
All right.
rest of our.
Comparing AKS to Stark.
Yeah, we can probably hit the highlights.
Yeah.
Most of this we've kind of gone over in the separate sections of Stark and AKS. I think one big piece to remember that Stark is physicians only. The AKS is for for anyone, and Stark is for DHS services only. whereas AKS is for items, any item or service. Stark, no intents required, strict liability, whether they meant to be non-compliant or not. In AKS, you have to have intent, and intent must be proven knowingly and willfully that they violated the statute. And then for AKS voluntary safe harbors, the more closely you fit within the safe harbor, the lower risk we would say that the arrangement is. But it's more of a weighing the risk level of the arrangement, whereas Stark, it's a mandatory exception and there is no gray area. It's either compliant or it's not. And then Stark, for a long time, people said Medicare and Medicaid were subject to Stark. In the most recent rules that they put out, they clarified that Stark was Medicare only and that Medicaid limited to the federal share payments to the states, but kickback is all, so all federal payers, Medicare, Medicaid, TRICARE, et cetera.
Yeah. And there's been new Stark and AKS updates, so you hear us often referring to the final rules, the most recent rules. I'm going to go to it on here because I can't read that. And so there's been updates and modifications to Stark law terms, so a number of terms that were confusing for a while. CMS has clarified what commercial reasonableness means, fair market value, taking into account the volume of value of referrals. There's also been additions of new safe harbors to the AKS. That includes the patient engagement and support safe harbor. In addition, OIG has expanded and given more flexibility to personal services arrangement and management contract safe harbor, which is often used a lot in many of the arrangements. In addition, the AKS has a local transportation safe harbor that's removed some of the limits on mileage as well.
They also added a new Stark provision for reconciliation, which at a high level requires that if there is non-compliance identified and no provider who was party to the arrangement has left more than 90 days or 90 days prior to the arrangement ending, that if you can reconcile all of the dollars that were inappropriately distributed, that you can do so and avoid filing a self-disclosure. It's more nuanced than that, but it provides an opportunity to kind of fix it. But it does require that the agreement actually was compliant on its face. So we've had some people try to use this when they had a non-compliant written agreement, which that doesn't work. So that would kind of undercut the whole purpose of the Stark law. You have to have a compliant agreement that there was truly like a mistake in the implementation of the written agreement that resulted in the non-compliance.
Yeah, and I think the key piece of that is like oftentimes physicians move from practices just as lawyers move from firm to firm. So you might not have everyone involved.
And it only works if you have a doctor that left 30 days prior but isn't willing to pay the money back if he owes money, it also doesn't work.
So again, some issue spotting things, just really high level, looking at whether you have medical directorship arrangements, suspect joint ventures, some of that we see often where it's not a joint venture on paper, but it has characteristics of a joint venture, physician employment agreements, physician ownership interests, loans made on preferential terms. So you might see this with ASCs as well. When they're opening up ASCs, the practice loaning money to certain people to join the ASC, charitable contributions, discounting practices, and so forth. So those are things to just keep an eye out for. Thank you. And we can skip this, given our time. Beneficiary inducement, mentioned this briefly earlier. And this basically provides administrative penalties for providing certain types of remuneration to Medicare or Medicaid beneficiaries. So this covers Medicare and Medicaid. And so this is basically you giving something to a patient in order to sort of get them to receive services from you. And so there are a lot of enforcement in this space as well. And remuneration implicating the beneficiary inducement law could also implicate the AKS as well. but the government has determined that certain items can be provided. So, e.g., if you give a smartphone for a diabetic patient to be able to track their insulin levels, so it's toward providing care, right? It is an item that helps the physician better provide care, and there are other elements that's required as well. And False Claims Act.
We can probably skip
we
through.
can- well, we've talked about the False Claims Act.
Yeah, we can probably skip through.
We can
pretty quick,
skip
just
through
to give them
this.
time.
And we believe the presentation will be available. Is that correct?
All the slides. Okay.
Yeah, so the slides will be available. We've talked about overpayments as well earlier.
You all probably know, the only thing we would probably add, given time on the False Claims Act, is that, they're often brought by private citizens or whistleblowers. So they're often key TAMs on behalf of the U.S. government. The government can decide whether they want to intervene or not. If the government intervenes and they find that there was, a violation of the law, then the relator gets a percentage of the money, so they have an incentive to kind of be a whistleblower. So it's just something to think about when you have employees, other people who have information. Sometimes you have practices that they're like, well, we're not going to disclose, we're just going to fix it and move on. And first of all, it's a strict liability. Under Stark, at least, it's a strict liability statute. Other, regulations aren't, but they need to understand it's more than just moving on and thinking they're going to fix it. They could also have someone internally that goes to the government, and it becomes a bigger problem for them.
Yeah. And they probably would end up paying much more if they just disclose.
It would be much worse for them.
So enforcement agencies, we've sort of touched on a number of them already during discussions. So the FBI can be involved, the OIG, CMS, also state departments. There are Medicaid agencies as well, licensing boards. So sometimes people are not thinking about that, but your licensing board could be involved, and that costs you your license to practice, which is a pretty punitive result. So we'll go on, knowing that we have 2 minutes left. Thanks for keeping us on track. So exclusions from the OIG. So there's also an exclusion statute, so we've talked about enforcement. In relation to exclusions, there could be mandatory and permissive exclusions depending on what the category is. So if it's a felony conviction, there's definitely a mandatory exclusion. If it's a conviction related to federal health care programs or services or patient abuse, that's also mandatory. For permissive exclusions, it might be because of a loss of a license, like non-renewal of license, submitting false claims, and so forth. And sometimes people do appeal exclusion decisions, so that's also available. Effect on exclusion, you can't bill, right? you can't receive payment for those services. And finally, ECRA, before we wrap up. So ECRA, as we stated earlier, is the Eliminating Kickbacks Recovery Act, and it makes it a criminal offense to offer, receive any remuneration in exchange or to order or induce a referral to a recovery home, clinical treatment facility, or clinical laboratory. So this is very limited in terms of who it covers and the providers it covers. However, it's very broad in terms of payers. So it's all payers across the board. And it also has certain exceptions. It has some similarities to the AKS, but also differentiations from the AKS as well. And it has a fewer exceptions, not as much as what you see under the AKS or the Stark, and oftentimes much more stricter exceptions.
Well, yeah,
And
we
the
can
practice
highlight
tips.
just a few of the high-level practice tips because we're supposed to be wrapping up. Diagrams are your friend. I haven't been practicing, 30 years, but I've been practicing 6 years, and I do fraud and abuse analysis all day, every day, and my brain hurts by the end of the day most days. But I love diagrams. They're helpful no matter how long you've been practicing. Details and facts matter.
Yeah.
Don't forget about state laws. The state laws are important. As they mentioned, there's many Stark laws, patient brokering laws. Florida, for example, has a very robust patient brokering law. Fee splitting statutes that should be reviewed in each state, and all payer statutes. at the state law level. Sorry, we
And-
skipped over a lot.
No, it's absolutely fine. Thank you both. So to put it in a nutshell, right, I mean, for our folks here today, some of us probably are starting out, some of us probably been practicing for a while, but occasionally encounter a healthcare issue that might
Yeah.
involve fraud and abuse. You had a slide sort of on the things to watch out for, but if you had to encapsulate it in 30 seconds, if this isn't something you do every day,
Yeah.
what should raise
Your
the
antennas.
red flag?
Sure. I think once you have certain types of arrangements where a provider is providing services and is receiving money for those services, like that always, like I'm like, okay, someone is getting paid,
Fine.
federal government is involved, they're paying for healthcare services, and someone is giving referrals for those healthcare services.
Not always, but sometimes too, it just doesn't feel right, right? Like you see an arrangement and you're like, that's a lot of money. Like, where is that money coming from? Why are they getting that money? I mean, a lot of times kind of the red flag is raised there, and then you start looking into the facts as to why. Like, why is one doctor making, you know, $1.5 million and one doctor's making $300,000? Like, you start to see kind of disparities, or, you know, we can't give a fair market analysis, for example, but you can see something that you're like, that just doesn't,
Yeah.
that doesn't, you know, pass the muster test. Like, that's
No one is paying $500,000 to come in one day a month to provide a service for 1 hour, unless you're doing like some crazy brain surgery that no one has done before. Yeah.
All right, thank you very much.
Thank you.